Well, welcome everybody. Thank you for coming. We really appreciate it. My name is Jeff Belomo. I'm an attorney with the law firm of Belomo & Associates. You are here this evening for what is called the Estate Planning Essentials Workshop. In our office, the first step in our estate planning process is this workshop. You will attend the workshop tonight, and I will offer you a free consultation in my office for an hour to an hour and a half to go over everything, to ask you lots of questions, to do what we call an estate plan audit. The cost of that meeting? Free. Absolutely no cost or obligation. At the end of the meeting, I will provide no less than 3 choices, tell you different plans and what they offer and what they don't offer, as well as costs associated with those plans. If you choose not to move forward, how much do you owe? Nothing. A handshake and a smile, that's it. So we are videotaping the presentation tonight. I appreciate everybody and their cooperation. If you'll take a look, you'll see there'll be a blue folder on your desk tonight. If you look on the left side of the blue folder, you will see that there is a pamphlet about why choose a certified elder law attorney. For those of you who don't know me, I am an attorney who practices solely in the areas of estate planning, business, and elder law. I have a Master's of Laws in Taxation. I have a certificate in estate planning, as well as being a certified elder law attorney. This little pamphlet talks about why you should choose a certified elder law attorney. On the right-hand side, this pamphlet is what I call propaganda. So the propaganda is all about our office, how good we are, and how smart we are. You can pitch this on your way out the door if you would like. You will see that there is a list of upcoming workshops on the left-hand side. Underneath that is a note sheet. Please feel free. Take as many notes as you can. If you have any questions, feel free to raise your hand. I'll certainly do my best to get to every and all questions. On the right-hand side, you'll see that there is a lot of information about different areas of estate planning. That just gives you some information, some background. Before you come in, a lot of people like to take a look at that just to get an idea of what it is. There are some areas of estate planning. I'm a lawyer. So the one thing that I do is I enter into contracts every day, right? So we're going to enter into a contract this evening, if you don't mind. I'm going to make you 3 promises, and you're going to make me 1 in return, okay? My promises to you are this. You're going to have a lot of fun. The time's going to go quickly. And you're going to learn a lot, okay? So if I do those 3 things, you're going to give me 1 promise in return. You're going to fill out the evaluation. Let me know how I did. It's that easy, okay? You didn't think it'd be that easy, did you? So you just let me know how I did on a scale of 1 to 5, 5 being the highest, 1 being the lowest. So 5 means, Jeff, you did an excellent job, thank you. 1 says, Jeff, find a new profession, you're horrible. I do take the comments very seriously. I do change my presentations just about every time I give them based upon the feedback that I get. So I'd really appreciate it. So do we have a deal?
We got a deal.
We're going to learn a lot. The time's going to go quickly, and we're going to have fun. And in return, you're going to fill out the evaluation. Save your time. Go ahead and circle all 5s now. That'll save you the time later. Good. See, we are a lively group. Good. Interaction. That's what we like. All right. So we ready to get started? All right. Very good. Now, I have a favor to ask. Do you mind if I take off my jacket to get a little relaxed? All right. I appreciate it. So let's get rolling. In every presentation that I give, I start with the same question. What do you want to know? You took time out of your busy life to come here tonight, and I'm assuming that you came for a reason. So what would make the next 2 hours a good use of your time? What questions would you like to know? You can go ahead and raise your hand. I'll call on you. What I'll do is I'll write all the questions down. I will make sure that I answer all of them before the presentation is over this evening, and we'll go ahead and take a look. Any questions?
Just briefly, somewhere along the line, deal with incompetency,
Sure.
the legal definition thereof, how it applies to contracts, to estate planning, and certainly to real estate owning, holdings, and what have you.
Okay, I will do that. Anyone else? Don't all jump at once. Go ahead.
How do I protect my assets? How do I protect the things that I've built up?
Okay. And by protect assets from anybody in particular? or anybody?
The taxman.
Okay.
Yeah, comes to mind. The, the kids until I want them to have them.
Okay. Very good. Very good. Anyone else have a question? All right. Well, one of the questions that Pat asked was about competency, and he mentioned a few things there. I believe you did mention the word powers of attorney, real estate.
That's implied.
Yeah. So I will talk about powers of attorney. Anyone else have anything they want to know about? With incompetency, how about I talk a little bit about guardianship? Go ahead.
Just came up last month, medical powers of attorney.
Okay.
We had issues with my mom and transferring her from the hospital to a rehab.
Okay. So medical POAs. With that, should we talk a little bit about living wills maybe, just so we understand that? Anyone else? We've got a quiet group in the back today, huh? Go
We're
ahead.
not as smart as these guys.
I don't know if you're gonna talk about it or not, but titling of assets, because now my dad's concerned about what happens if something happens to him. How does he
Right.
most easily title assets? Like, can he put my name on the deed of the house, that
Yep.
kind of thing?
Perfect. Good question.
When is it a good idea to start gifting part of your estate?
Okay. Very good. Well, I only have 2 hours. So I will do my absolute best to cover every one of those in depth. The one thing that I'll ask in return is that I will absolutely be committed to answering all those questions. If for some reason there's something that we end tonight and you don't have a complete clarity on, please see me afterwards. I'll stick around, or feel free to take me up on the free meeting in my office and we'll make sure that we answer all of your questions that we have. I want to make sure that tonight's presentation is as broad as I can make it in the estate planning arena. So for those of the people who are watching this on DVD, they get a very broad concept of estate planning, and I don't want to get too focused on nitty issues. So we'll make sure we address all of them. Okay, well, why do we do it? It's the family, right? The whole point of tonight and the whole point of this workshop is to shift your perspective. Everyone comes into this workshop with a preconceived idea, with something in their mind as to the way the world works, the way that estate planning is, right? I'm an estate planning and elder law attorney. This is what I do for a living. My perspective is a little different than yours. I see it in the real world. I see what happens every day. So my job tonight is to just get you to think about things maybe a little differently. Think about it from my point of view, okay? Can I be blunt with everybody? This happens every time. Every workshop that I've ever given, one of the first questions that's always asked is, how do I protect my stuff? Okay? I think what was asked was, how do I protect my assets?
Right.
But the technical term that you'll hear me talk about is stuff. Okay? So how do I protect my stuff? Why is it that that's the question that we always ask? Does anybody have an idea?
There's so many forces out there that are looking and have their fingers out to put it in your stuff.
Exactly. Exactly. Society tells us that stuff is what's important to us. But I'm going to push back on that a little bit. What is really most important? Our family. Okay? So that's what I want you to think about tonight. Everybody came in here thinking stuff, assets, protect, against taxes, against kids, against nursing homes. Everybody came in with a certain view in mind. No one's ever raised their hand at the beginning of this presentation and said, Jeff, how do I protect my family in case I become disabled? How do I protect my wife? Never been a question. Now, I admit, impliedly, is that what you meant by how do I protect my assets? I don't know. I guess we could argue that, right? So that's what this is about tonight. Family is the most important thing, okay? What can be done? Those are the rules. That's easy, right? That's the tax code, that's the Medicaid rules. The rules are very easy. The secrets, that's what we do in our office. We take what is important to you and your personal planning goals, we massage it with the rules, and voila, we come up with a personal plan just for you, okay? But what do we need to start with? what is estate planning? We're here for an estate planning workshop, so I think it's very fair to say the first question we need to answer is, what is estate planning? Now, I have actually polled every person in the room at previous workshops, and every single person gave me a different answer as to what estate planning was. Can anyone tell me why there's a different answer for every person?
Each person has a different situation.
Absolutely. That's exactly right. I just want to start with a basic definition. Now, for those of you in the room who are conspiracy theorists, I don't have an agenda. I'm not trying to lead you down a path. I simply want to get just out into the forefront, what is estate planning? I want to control my property while I'm alive and well. Can anyone tell me what the key word there is?
Control.
Control, right? Who wants to give up control? Nobody. And I want to plan for me and my loved ones if I become disabled. Now, in that second sentence, what is the key word?
Plan.
Okay, how about another one? Disabled,
Disabled.
right? What's that?
Or deceased.
Or deceased, right. And in this sentence, I said the word disabled. Why is that important? Well, were there nursing homes 30 years ago?
No.
Some,
So.
a couple, right? Were there as many as there are today?
No.
Not even close. Why? Why is that?
Aging population.
Aging population, right?
Big money for the politicians.
Exactly, right? This is my favorite. Medicine has come so far. Replace our knees, replace our hips, go in for a heart, transplant or go in for heart work, take a pig valve here, replace it here, switch this out. It's like an oil change, okay? It's amazing how far medicine has advanced. But has medicine advanced at the same level for our minds? No, right? We are living longer, and unfortunately, our minds aren't able to keep up with our bodies. So here we are, we come to a place where we become disabled. One of the main things that I focus on in my practice is not practicing traditional estate planning. And what I mean by that is traditional estate planning doesn't plan for disability. Traditional estate planning is a death plan, right? We do a will, give everything to our spouse, give everything to our kids, figure out what's going to happen, okay? That's not what I like to focus on in my practice. Now, do I do that stuff? Of course. But my goal is to make sure I focus on the disability piece. It's becoming very prevalent these days, and I think it's only going to become more prevalent as we age. So, to get away from all this legal technical mumbo jumbo, let's talk about what is really estate planning. I want to give what I have to whom I want, when I want, the way I want. And when I die, I want my assets to go to the people that I love without unnecessary cost or delay. Fair enough?
Fair enough.
I have no hidden agendas. I just want to get a definition. Okay. So what have we heard on the streets? What do we hear in the coffee shops and in the barber shops? Do I need a will or do I need a trust? I have a vote for both.
Yeah.
Does anybody want to vote for something else?
None.
Anyone want to vote for I need just a will? Anyone want to vote for I need just a trust? Quiet bunch tonight. I'll tell you. All right. One of the things we're going to do tonight, we're going to have fun. I'm going to ask a question and you're going to get it wrong. And then we're all going to laugh, like we just did, we're all going to laugh, and then I'm going to tell you why you're wrong, and then we're going to move on in the presentation. So, the answer to the question of do I need a will or a trust? Neither one works. You don't need either. Save your money, you don't hire a lawyer, don't worry about it, right? Yeah, you obviously know I'm joking, but neither one works, and I'm going to prove it to you. I'm not going to just make a statement and not prove it. And this is going to answer one of the questions in terms of asset titling that we talked about. How do you own your assets? Okay? Do you own them jointly? If I own a joint account with my spouse and I die, what happens to that account? It goes automatically to my spouse. Okay? Do we see the line over? Now, if I have what is called a non-probate asset, can anyone tell me what a non-probate asset is? Okay? A non-probate asset is an asset that has a beneficiary designation right on the policy. So the policy will say the beneficiary is my spouse, is my son, is my daughter. So I want to ask, upon my death, if I own an annuity and it lists my wife on the annuity contract and I die, where does that annuity go automatically upon my death? To my, okay. Okay, all of those. An insurance contract. If I have an insurance policy that names my wife, it goes automatically to my wife. Does she need to go through probate? No. Does she need to stand on her head?
No.
Does she need to jump up and down? Right. So what happens is she gets a death certificate to prove that I'm dead. She goes to probably to the advisor who helped her with getting that policy in the first place. They fill out the claim form. A check comes in the mail. Pretty easy, right? Now, POD stands for payable on death, typically with savings bonds. TOD is transfer on death, typically with brokerage accounts. And ITF is in trust for accounts. Those are typically with banks. So I ask, if I name my spouse on all of those accounts and I die, what happens? It goes automatically to my spouse. Do we all agree? Okay, now, let me ask you, what does RLT stand for? Any takers? Revocable Living Trust. Okay? Revocable Living Trust, a lot of people know those as probate avoidance trusts. Okay? Ways to avoid probate. We'll get into this a little more later, so don't get too hung up on it for now. But does anyone notice that box is open?
Yeah.
Why is that box open?
Exceptions.
Right. So the box is open because I can change my mind. So if tomorrow I want to take stuff out, I go and take it. If I want to put stuff in, I put it in. Right? If I want to cancel it all together, I cancel it all together. Okay? A will. Once I die, my will is a closed box because at that point, once I die, can I change my will when I die?
No.
No, I mean we're dead, so I don't think that's a possibility. So let me ask, in all of those cases that we had a joint asset and I died, if you did the world's best trust with me or the world's best will with me, what effect did those wills or trusts have on any of those assets? Not a one. None. Wow. Amazing, right?
If you're speaking spouse,
Yeah.
correct?
No, I can speak anything.
You could
So let
say
me ask.
The neighbor, guy across the street, and I use him as my,
Yep.
just fill in the.
Let me give you an example.
Yes, please.
And absolutely. So, trust or will had nothing to do with that, right? We don't need any of those for these things. Now, I want to make sure we understand it. So, I'm going to use your example. I name as my beneficiary of my life insurance policy my neighbor Ted. Okay? Ted's on my life insurance policy. My will says everything to my wife. My trust says everything to my wife. And I die, where does that life insurance policy go? It goes to Ted,
Ted.
right? Because the life insurance has nothing to do with probate, nothing to do with wills, nothing to do with trusts. So I think we have a fairly good concept. So do we all agree that this works? Okay, well, welcome into my world. I have a question. How did you die? Anyone want to give me an example of how somebody could die?
Cancer.
Cancer, okay? Suddenly or prolonged? Let's do suddenly, just for argument's sake. If I die suddenly, it might work, right? Depends on my tax situation, depends on a few minor things. What if I'm in a coma for years? How well did all that work for me? Okay, the joint account might have worked, but all the other things that get paid out upon my death, did it pay out?
Yeah.
No, it didn't pay out yet. Why? Because I'm still alive, okay? I'm going to hit home with a few of you in the room. A lot of people like to add their son or their daughter to their accounts, right? There's a lot of reasons to do it. There's a lot of reasons not to do it. We'll talk about that later. But for the purpose of right now, I just want to highlight something. If I name my son as a joint owner on my account, and my son and I are in a car accident, who probably is my son's power of attorney? His spouse. She'll take care of my other kids, right? She'll do the right thing. Yeah. Right? It's okay that my daughter-in-law has complete access to all of my money. Ooh. I don't know, right? Something we got to think about. If I die suddenly, that might not be a problem. But if I'm in a coma and my son's also disabled, I have a problem because now my daughter-in-law has access to all of my money. If I had a quarter for every time somebody called me and said, Jeff, my mom died last month. I need to come in and see you. But don't worry, all of her bills are paid. I paid them all today. I say, with what authority did you pay all the bills? The power of attorney. Financial power of attorney ceases at the moment of death. Can anybody tell me what I call a power of attorney with no instruction? The durable power of attorney that gives you permission to transact business on my behalf, I have a word for it. Foolish. A blank check, right? I give you a durable power and I don't tell you what's important to me. I don't give you instruction. You got a blank check. Now, a medical power of attorney, on the other hand, ceases either at the moment of death or if you have what is called a living will or an advanced healthcare directive, that document takes over. And what that document says is, if you're permanently unconscious, terminally ill, vegetative comatose, 2 qualified physicians say you have no chance of survival, no chance of coming to life, you do want or you do not want heroic or life-saving measures. Now, when does a medical power of attorney cease? Depends completely on whether or not you have the living will. If you have the living will, then that takes over at the moment of your permanent unconsciousness or terminally ill. You decide, not your spouse, not your loved ones. You decide what you want to have happen. Please have that document. Don't make your spouse or somebody you love make the decision if they should pull the plug or not. They don't want to have to make that decision in that moment. It's too stressful. Even if they know what you want, it's still a very difficult decision.
So, let me
Okay.
just try to understand. So the medical
Yep.
POA is the first document, so when someone's conscious, they're giving you the opportunity to advocate on their behalf medically.
Yep.
And then it transitions to the living will the moment that they become unable to make the decisions themselves.
Now, the living will doesn't take effect until they're permanently unconscious, terminally ill, vegetative comatose.
Okay.
Okay? That's at the end of life decision. Have we heard that phrase? That's when the living will kicks in. Okay? So if I call a financial power of attorney a blank check, what do I call a medical power of attorney with no instruction?
Switch.
The God power. Switch. The God power, right? So you want to have instruction, and we'll touch on that later. If you don't have a power of attorney and you become incapacitated and can't now make one, what is the process by which we appoint somebody? Guardianship. Okay, you talked about it earlier. Guardianship, has anybody been through the process? Okay, let me tell you about it. You have to allege...
Is that the same as a beneficiary? Have you made them both the same?
No. A power of attorney is a document that authorizes somebody else to make your decisions. But if I become incapacitated before I can make the power of attorney, somebody needs to step in to help me. But that somebody isn't just necessarily my spouse, because if I have accounts in my own name, my wife can't touch those accounts. Okay? So the only other way other than a power of attorney is a guardianship. So the spouse that I have been married to for 45 years has to allege in a court document that I'm incapacitated, I can't handle my own affairs, I can't take care of myself, and that she or he should be appointed as my guardian. Then somebody has to read that petition to my spouse. Your husband of 45 years hereby is declaring that you're incapacitated, and there will be a hearing in courtroom 6 of the Judicial Center on the 6th floor at 10:45 a.m. on December whatever. Well, for those of you who have a family member who's disabled, am I correct in saying that just because they're disabled, that doesn't mean that they don't understand what's going on sometimes, right? So I recently had a husband and wife who were married 45 years. I begged the husband for years, please get the power of attorney, please. In fact, in your situation, I think it's more important than any other document you could possibly have. He didn't do it, right? Save a couple $100, right? Save them a lot of money, right? No. Wife becomes incapacitated. She has accounts in her own name. He can't access them. He can't pay the bills. He can't help her in any way because the money's frozen. She set up the bank accounts because he was at work. He wasn't there, so his name isn't on the account. He's irate because he's showing the bank officer. My pay stub shows that that money went in that account. Does the bank officer care? No. Right? So he had to allege that his wife was incapacitated. We had somebody read the petition to her. We show up at the courthouse because she has to be there. The alleged incapacitated person has to be in the room. So she's sitting in the room and she's a broken record. And all she keeps saying is, we were married for 45 years and this is the thank you I get? You ought to be ashamed of yourself. Well, he's in tears. I'm in tears. So much for the stoic lawyer, right? So then the judge says to her, ma'am, I need to ask you a few questions. Do you know why you're here today? We were married for 45 years and this is the thank you I get? Do you know what you had for lunch today, ma'am? We were married for 45 years and this is... She didn't have any memory, but she knew enough to know something was going on that she didn't like. Do you think that was hard on him? Oh yeah, right? Guardianships can cost anywhere between $2,000 and $5,000 depending on how much the doctor charges to testify, how much the lawyer charges. You have court costs, you have serving costs, you have all kinds of fees. Okay, that's a lot more money than a simple power of attorney. Okay, so those are documents that everybody should have. I don't care how young you are, I don't care how old you are. Disability doesn't have an age. Disability doesn't necessarily just attack older people. Every one of us have a really good shot at becoming disabled at some point.
Before you leave that power of attorney, what if there is more than one name on the power of attorney that the person?
That's fine. Yeah, you can name more than one. Depends how you write the document. No. It depends how you write the document. So you can write the document that says that they have to act together, meaning all of them, either 2 or 3, have to agree. Or you can pick jointly or severally, meaning any one of them can act.
They're the two primary options in writing such a document.
Yeah. Yeah, and there's so much planning and questioning that goes into that. I mean, every situation is different. So you might have a situation where both of your kids live away and you don't know who's going to be able to act first. So you just say, hey, either one, whoever can get there first, do it. You might have a situation where one kid lives close, one kid's far away, but you don't want to slight the kid that lives far away, so you still give either of them. And other people choose, you know what, I'm picking. I'm going to pick the one I trust, whether they're close or not. So that's it's a counseling issue. We'll talk later about how important counseling is. That's just a counseling issue. Now, we talked all about joint assets. We talked all about owning assets jointly. What did I not talk about? It's a hint. It's up there. Individually owned assets, okay? So if I own an asset in my own name alone, and I die, that asset goes automatically to the person that I name in my will, okay? People will often ask me, Jeff, I have a will. Does my will have to go through probate? Yes. That is the definition of a will, is that it goes through probate. Now, I assume you're going to ask the question, Jeff, what is probate?
Yeah.
Oh, it's funny you should ask. It's the next slide, right? Probate is just simply the formal process by which we take your will and we appoint the executor. The executor steps in your shoes and then carries out your wishes and gets the assets to the people to whom you want it to go to. Okay? So probate is just simply the formal process by which we carry out your wishes. Okay? The executor is the person who steps in the shoes, because what happens at death with the power of attorney? It dies. So the executor now is the one who takes over. So the executor goes to the attorney, fills out the probate petition, goes to the courthouse, and the executor takes an oath. I will duly administer the estate and abide by inheritance tax provisions, and signs the document. They are given short certificates. The short certificates are what I call the golden ticket. That authorizes the executor to transact business on their behalf and to do everything they need to do on behalf of the estate. Okay? An inheritance tax return has to be filed within 9 months of the date of death. You can get an extension up to 15 months if you need it. That's the time by which we're selling assets, we're moving things, we're doing what we have to do. Okay? Now, the thing about probate is that it is by definition the state's rule book. The state tells us exactly what happens in the probate process. So the state says, hey, if you're a son or daughter or a potential beneficiary and you want to contest the will and say that mom or dad didn't have capacity, all you got to do is walk down to the Register of Wills, fill out a form. You've now contested the will and you'll get your day in court. Okay. In some of the trusts that we draft, we do what is called the anti-contest provision, or more technically known as the don't mess with me provision. Okay? That's the technical version. What that says is, hey, I'm going to leave you a little bit of money in this trust because I love you, but if you even argue that I didn't have capacity or that there's something wrong with any terms in this trust, guess what you get? Nothing. It's as if you predeceased me. So son or daughter, think long and hard about whether or not you want to argue that this will or this trust isn't valid. Now, in the state's rule book, can I do that? No, because the state says that you're allowed to contest it. So That's just something. The thing about probate is that simply it's the state's rules and they decide what can and can't happen. If an executor decides they want to resign, a formal accounting has to be done. And there's a lot of little rules that go on. I am not one of those attorneys that preaches and that you've got to avoid probate and it's the worst thing and oh my goodness, oh my goodness. There were a lot of lawyers and insurance salesmen who went around and preyed on the elderly and got them to go into these really expensive revocable trusts, also known as probate avoidance trusts, to avoid probate. Oh, lawyers' fees will cost so much money, and oh, you got to avoid this and you got to avoid that, and no, just spend, give us $10,000, $12,000 and we'll take care of it for you. Are you kidding me? Probate is a public process. So what I mean by that is if I die, you can go down to the courthouse tomorrow and pull my probate file, and you can see what I died with. So I have a lot of politician clients who don't want that. They don't want their constituents to be able to go and look to see what I died with. That's I could see where they're coming from. So they do a revocable trust purely to avoid probate. That process is not a public process. You can't go look at my revocable trust, okay? So that's simply what probate is. The main thing is simply that it's the state's rules. What is a trust? A trust is a legal document that allows you to supersede the state's rules. Okay, it allows you to make your own rule book and you decide what's going to happen. All right, there's a couple types of trusts. There are testamentary trusts and there are living trusts. Can anybody tell me what has to happen for a testamentary trust to be in effect? I have to die. So if I'm in a coma and I provided money for my son who has a disability, does my son get any of that money? No, because I didn't die, right? Traditional estate planning was a testamentary trust. Not as effective anymore, right? Because we're not dying as much. We're becoming disabled. Okay, now, am I telling you that I don't do them? No. I have 20, 30, 40-year-olds who have a 3-year-old at home. They want to make sure that they provide for the kid. Okay, statistically speaking, that's a risk I'm willing to take. Now, could I be wrong? Well, of course I can. Go ahead.
Is there such a thing as a special needs trust that's testamentary?
Yep, there's several types of special needs trusts. So there are first-party special needs trusts, which is the money from the individual who's disabled. And there are third-party trusts that you can set up, that you can create during your lifetime, that will be in effect for the person who is disabled so that they can still get their public benefits and get their rights. So you can do that while you're alive for the person with a disability. Yep.
But is there such a thing as one that is created at death?
Oh yeah, I do those all the time.
Okay.
In every document that I create, every will that I create out of my office, there is embedded in it a special needs trust, okay? Because I know what happens in life, right? Grandparents and parents never intend to cause a problem for a grandchild who's disabled. You would never intend to do that. But if you give a little bit of money to somebody who's disabled, did you just cause a problem? Yeah. So absolutely, that's in every document I create out of my office. A living trust. That's a trust that I create while I'm living. How about that for creativity? There's two types, revocable and irrevocable. Revocable means, remember the RLT earlier? I can change it, I can do whatever, I can put whatever, I can do whatever I want with it, okay? Irrevocable or irrevocable, depending on how I say tomato, you say tomato. Irrevocable, I have an easy way I learned in law school to remember what irrevocable means. Irrevocable means non-take-a-backable. I'm all about legal terms, huh? Okay, now, let me ask you a question. Do we all agree then that irrevocable means that I can't change the document? We all agree? That's wrong. And here's why that's wrong. That's what an old tax trust used to be. So years ago, and I'm going to show you an example of it, the federal estate tax limit was much lower, okay? At one point it was 600 and some thousand, then it was 2 million, and then it was 3.5 million. Now it's 5 million, and we'll talk about that. But when it was much lower, people were trying to find a way to get it so that those assets would not be included in their estate. So they used an irrevocable tax trust. But in order to get the benefit of it, you had to give up right to the money, give up control to the money, can't touch the money, can't be the trustee, can't have somebody subordinate to you be the trustee. Who wants to run out and do that? No. Those are the olden days, okay? That's what we all think of when we think of a trust. Now, there are what we call in our office estate planning trusts. so that we can plan for ourselves while we're alive, also while we're disabled, and then of course upon our eventual death, we also have control as well. It doesn't mean that you can't change a document, and we will talk about that later. Keys to an effective estate plan. What's the major key? I want to have control, right? Do we all agree?
Mm-hmm.
All right, very good. We have to talk about what to do, how to do it, and the personal instructions. So the personal instructions are our instructions to the people we love about what we want to have happen. And of course, it's essential that we make sure that we list proper asset ownership. So now, many of you I know are observant. Who noticed this when they walked in the room today? Everybody did, right? What is it?
It's a wagon.
A Radio Flyer Red Wagon.
Oh.
Who had one as a kid? All right. So let me ask you, Lou, who got to play with it?
I did,
I did, absolutely. Anybody else?
only if I wanted to.
Only if I wanted. What went in it?
All my toys,
All your toys. What came out of it?
whatever I want to play with.
Whatever you wanted to play with. May I present to you a trust? Okay? You will never look at a Radio Flyer Red Wagon the same way again. Now, you're thinking, this guy is crazy. He's crazier than what he looks. No, I'm not, and I'm going to prove it to you. Who gets to play with it? The trustee, right? Who gets to choose the trustee? Me. Could I be the trustee? Absolutely. If I die or become disabled, who plays with it? The successor trustee. What goes in my trust? Those are investment instructions. What comes out? Distribution instructions. Do I get to control all of it? Amen. Right?
Mm-hmm.
So, if I walk through life and this box represents everything that I own, whether, I don't care if it's $1 or $1 million, let's not get hung up on amounts. But I own this. This is everything I represent in my life, everything I own. And I'm walking around in life with everything on my shoulder and I become disabled. What happens? The box falls to the ground. Who picks it up? I'm disabled now. Power of attorney, right? Power of attorney comes in and picks it up for you. Now, I'm walking through life and I die. What happens to the box? Who picks it up? My executor, right? The executor steps in my shoes. Now, let me ask the question. Everything I own gets put neatly in my trust or in my Radio Flyer Red Wagon. I'm going along in life and I die or become disabled. What happens? Hold on, let me do that again. Don't all yell at once. I die or become disabled. What happens? The handle falls. Did we hear it?
Yeah.
Who picks it up? Yeah, who picks it up? The trustee. Now the trustee dies or becomes disabled. What happens? Handle falls. Who picks it up? Successor trustee. Trust never dies or becomes disabled. There's always somebody to pick up the handle. Now, in a workshop not too long ago, there was a nice lady in the corner of the room who was, I could tell, very confused. So I finally stopped the workshop and I said, please tell me what you're thinking. And she said, is a trust like a vault somewhere that all my money is shoved into and all my assets are... I said, like a physical vault? She said, yeah, like, is it like a big vault? I said, no. A trust is the document itself, okay? So who drafts the trust? The attorney, okay? So the trust provides all these provisions we're talking about and everything. And then what I do is I fund the trust. And all that I mean by that is I take your assets and I title them in the name of the trust. So if I walk into the bank tomorrow and I say, bank teller, I would like $10 out of my account, and I hand them my valid ID. And I say, it's the Jeffrey R. Bellomo account, and I am Jeffrey R. Bellomo. What will the teller do? Will she hand me $10, assuming I have $10 in my account? Absolutely. It's my money. Now, let me give you another example. I walk in and I say, hi, bank teller. I'm Jeffrey R. Bellomo. I'm the trustee of the JRB Trust. Here's my valid ID. Trustee controls the trust, right? They don't own the trust, they control the trust. Does she give me $10 out of my account?
Yeah.
Absolutely. Why? Because I'm the
Trustee.
trustee. So did anything change? Nothing changed,
No.
right? Still my account, I'm still the trustee. I still have access. I still have control. It's nothing more than a mere titling of the asset. That's all it is. There's no vault. There's no hidden place. Go ahead.
Trustees' rights and privileges are concurrent with your life. In other words, while you're still living,
Yeah.
I'm named your trustee.
Right.
I can go and get the same $10 that you got, or
Yep.
another $10 bill.
Yep.
2 days earlier.
Absolutely. Yeah. And in some trusts, there's one trustee. In some trusts, there's co-trustees. And then upon my death, as the trustee, you continue.
Yes.
Right? Never dies. It always keeps going. Okay? So this isn't a foreign, I mean, it's the exact same way it is today. Your assets are just simply titled in the name of the trust. So it would just be Jeffrey R. Belomo, trustee of the JRB Trust, as opposed to the Jeffrey R. Belomo account. Same functional difference, right? It's the same thing. All right? So does everybody understand what a trust is? Go ahead.
Real estate, would you have to transfer the title to the trust?
Yes, absolutely.
So all your title would have to transfer?
Yep. Yeah, and there are a lot of different types of trusts, and we'll talk a little more later about the different types of trusts. So I don't want you to get too hung up on the details because, but yes, you need to title everything in the name of the trust. And there's pros and cons to doing this. So don't run out and just do it without having advice.
Maybe follow on, is that a taxable transaction?
It depends. So it depends on what type of trust you're creating. Later in the evening, we're going to talk about trusts that we're currently using that are tax neutral trusts. And what that simply means is that I can put these assets in the name of the trust and there's no taxable event. It's as if it never happened for taxes. And that's a good reason, and I'll explain later as to why it is. We okay with that concept?
Yeah.
You guys are great. TLC, this is the estate planning strategy that we use in our office. Tender love and care, right? Now, it stands for thorough, lifetime, and complete. So in my office, thorough means you don't just walk in and I don't take 10 minutes with you and say, okay, where do you want all your assets to go? Okay, if you die, who's the beneficiary? Who's the secondary beneficiary? No. This workshop is part of my process, and then the vision meeting will also be at least an hour. I ask at least 15 questions, a lot more than that. We go through it, we counsel, we make sure that we put you in the right situation. This isn't just some random trust mill or some random document warehouse. It's not word processing. Okay? How many people have a will currently? All right, you ready? I'm going to read it to you. Now I want you all to close your eyes and think of your trust.
Trust or
Of your will. Okay, I want you all to think of your document is what I meant to say. You ready? I, Jeffrey R. Belomo, hereby, being of sound mind and body, declare this to be my last will and testament. How am I doing? Okay. It's going to get hard on me now. You ready? Upon my death, I want my beneficiary to be my spouse. In the event my spouse predeceases me, to my children equally. So far, my debts, cost of administration, expenses shall be paid first and foremost. Am I doing all right? My spouse shall be my executor. If my spouse shall predecease me, then it's my eldest child. Now, for those of us who are Italian, I can say this because I am, it's the oldest male child. Right? Absolutely, yeah, we're all agreeing. Yeah, maybe it's, I don't know, I'm Italian. I can only speak for the Italian household. How did I do? Pretty good, right? I read your will to you. Now, why is that? Because it's a standard form. So you come in. Now, for those of you in the room who have a lot of assets, and you have millions of dollars, and you have trust set up, don't get too excited. That's button B, right? Hit B, now all the sub-trusts come out, okay? That's not what we do. As you can see from tonight, from the thoroughness that we're doing, the vision meeting, we counsel. We make sure that we ask you all the questions. I will provide no less than 3 options. No less. I will tell you what 3 options are. I will tell you the costs associated with those choices, what they do, what they don't do. Okay? 3 options. The cost associated, I leave the room, you tell me what you want to do. Okay? It's about counseling, it's not about word processing. All-inclusive updating program. So, does anyone want to tell me what the average update is in between estate plan updates? How many years?
I'd say 10 to 15.
10 to 15. Higher.
20?
20.
Mine was 40.
Well, then you beat the national average. Now, let's think about why that
The
is.
lawyer is still in business.
Yeah.
I found that out.
Well, that's good. That's good. Now, let's think about why in life. Okay, we get married. We have our first kid. Okay? Then our kids have kids. Yeah, you have no assets. Then your kids have kids. Then you're about to retire. And then you decide you need a plan for death. About 20 years apart? Right? I mean, I'm being pretty vague here, but 20, 25, 40, 45, 60, 65, 80, 85, right? You should be looking at these documents at least every 1 to 3 years. Now, I did not say you should change them every year. I said you should look at them every year. Make sure that nothing has changed. If you went to make changes to your document and you called my office and you got a bill for $225 an hour for every time you called me, how often would you call me? Never. Every 40 years. Right? And I don't blame you. Okay? This is way too important to be waiting that long to look at or to address. What could change after you do your will? Give me some examples of what could change. Marital status.
Your health,
Tax laws.
Tax, yep.
your health
Health.
Health.
for us older people.
Yeah, right? A lot can change. How about the economy? We know that all too well, right? What we offer in our office is what is called an inclusive updating program, lifetime. Okay? You create advanced trust planning with us and trust with us, and what we say to you is, hey, in return for a very nominal amount of money every year, we will give you unlimited access, reasonable unlimited access to me and to my staff and to my entire firm. So, you decide one day you want to write out this child or write out that child or redo this or redo that. You pick up the phone, you call my office, we make the changes, you sign it. How much do you owe me? Nothing. Okay? Pretty good. Your advisor calls me. We answer all of your advisor's questions. How much do you owe me? Nothing. Your accountant calls me. Nothing. Also, upon death, I am willing to tell you in writing that my fee will not exceed 1% of the value of your estate. Under no circumstances. The average around this area is 5%. But I'm going to cap it. Why is that? If I see you every year and we meet in this room and we go over all the law changes, everything that occurred that year, everything that happened, we allow you to make changes, how worried am I about how cumbersome your process is going to be? I'm not. Because I've seen you every year and I know exactly what we have. So I will put an automatic cap on it, okay? That is my promise to you. The planning pyramid. This is my favorite part of the evening, I think. How many of us know what an estate planning pyramid is? Everyone know what a pyramid is? Okay. A pyramid, the foundation of the pyramid is always the most important. So when you walked in tonight, I told you what was the most important thing. Your family. Okay. Now, I'm going to prove it to you. I'm not going to just make a statement and not prove it to you. So, if in this hand I have the loved one, the one person in your world that means everything to you, but that person had what used to be known as an incurable disease. Lucky for you, guess what I have in this hand? The cure. But what do you need to give me for me to give you the cure? Everything you own. Every last penny. What do? You give it. Okay? There's always one wise guy in the room that will say, well, it depends on what kind of day I'm having. No. It doesn't matter what kind of day you're having. Every day you're going to give the money over. So that proves to us that the family is the most important thing. Do we all agree?
Mm-hmm.
So, if we're going to put on our screen the base of the pyramid, the most important thing is our family. That's wrong, but that was a very good guess. I appreciate your enthusiasm. What's the most important thing? Me. Right? You get on an airplane. The flight attendant comes to the front of the airplane and says, in the unlikely event of cabin loss pressure, a mask will fall from the ceiling. If this occurs, please secure your mask first, and then help the elderly and the children around you. Why do they say that? Because if you're passed out or dead, how well can you help the others around you? You can't. You can't help them. Look, we go around in our lives worried about everybody else. Worried about our kids, our grandkids, our parents. For once in your life, you have permission. Worry about you. Because guess what? if you pass out or die or become disabled, there's nobody that can help you. So, the most important thing is me. Several of you in the room know my wife very well, and I'm not as dumb as I look. So, who else is the most important thing?
Spouse.
My spouse, yes. Then, our family. Now, the more we go through life, we hope to accumulate more money. The more money we have, the more we pay in
Tax.
taxes. The more money we have, who else wants it?
Everybody.
Creditors and predators.
And government.
Can somebody give me a definition? Actually, Lou did earlier, but can somebody give me a definition of a creditor? Who might that be? Who might be a creditor? You said earlier, taxman,
Taxman.
mortgage,
Mortgage.
somebody I accidentally kill in a car accident, or their family, God forbid. Who else might be a creditor?
Convalescent,
What's that?
convalescent.
Home, nursing home, right? A lot of creditors out of there. Who might be a predator? I have somebody in particular in mind, and you already mentioned it earlier, but who might it be? Who's a predator that you don't want to admit? Your family, your kids. Could be intentional, it might be unintentional. Okay, and what I mean by unintentional is we transfer the assets to my son, right? There are a lot of reasons to do it, there's a lot of reasons not to do it. You talk to a lawyer about it, whether you should or you shouldn't, but let's say you did. You transferred all the assets to your son, and your son says, "Thanks, Dad, I appreciate it. Now get out of here." Can I make my son give the money back? No. A gift is non-take-a-backable. Once I give it, I can't require it to be given back. I had a lady who came in my office, 85-year-old, adamant that she was transferring all of her assets to her 60-year-old son. "I want to do Medicaid planning," she said. "There's a 5-year look back, you know." Yeah, I know. This is what I do for a living. She said, "But I read in Reader's Digest that if I transfer everything to my son, I'm good." I said, "Yeah, that's okay. But let me ask you a question. What if he kicks you out of the house? What if he doesn't give you any money?" Won't happen. My husband died. He took care of me every day. He fed me. When I was ill, he was in the hospital every day. Okay. I said, what happens if he becomes ill? What if he goes into a nursing home? What if he has to file bankruptcy? What if he kills somebody in a car accident? Or my best example, what if he gets divorced? Or all of those things that could happen. Do we all agree? Yeah. Am I in big trouble if any of those happen? Yeah, because guess what? Who owns the money?
He does.
He does. So guess who doesn't own the money?
You.
I don't. So it can be intentional or unintentional, but whether it's intentional or unintentional, there's still a predator potentially. Now, often in these meetings, nobody wants to admit that. No, not my kids. So, in the example I just told you about, the 85-year-old lady transferred all of her assets to her son. I made her sign a release and a waiver saying that I didn't recommend it. I wasn't saying it wasn't a good idea. I didn't think she should do it, and here's all the reasons why. She signed it. She called me a few days after the deed was transferred, crying. She got home from the grocery store. Guess what was on the door? An eviction notice. Bye-bye, Mommy. She calls me crying and says, "Jeff, what are we going to do?" We? Is there a mouse in your pocket? We. So, yeah, very sad story. And it's absolutely horrific. Okay, but there's an example of she never saw that coming. She was so upset. She even told me, "I was so upset with you when you even thought that was a possibility. You were right." I said, "Hey, I don't want to be right." Right? A team approach is critical. All right. So we're about halfway in the workshop. And by now you have already made a determination. Either I know what I'm talking about or I don't. Is that fair to say? Yeah.
Yeah.
Now you need to promise me something. You are not going to call the disciplinary board in Pennsylvania and tell them what I'm about to say. I don't know everything. I know. I'm just as shocked as you are. I don't. So what does that mean that I need around me? Your team. So who might be on your team? Shout out some people who might be on your team. An accountant. Who else might be on your team?
Advisor.
And a financial advisor. Absolutely. How about your
Kids.
How about your kids?
How about your pastor?
How about your pastor? Never had that said before, yeah. So here's my thing. I offer you a free consultation in my office. Okay? But here's one thing that I want to ask in return for that for that gift that I'm giving you. What I'd like to ask is that when you come to the meeting, particularly if you're even considering some of the things that we're talking about tonight, that you bring your team with you. Because here's what happens. You come, we meet, we spend a good hour together, we get this plan in mind. You leave my office, you tell me you're going to do it, we start moving forward. You call your son or daughter, and guess who has questions? They do. So they call me. I spend a couple hours on the phone or an hour on the phone with them. A few days later, you tell your financial advisor about what we're doing. Your financial advisor wants to talk to me. So guess what they do? They call me. Your accountant, he or she calls me. I'm not doing very well because I gave you a free consultation and to date, I'm not being paid, right? So all I ask you is, if there are members of your team that are important to you, bring them. My favorite meetings are when my table is filled with your advisor, your accountant, your family. And guess what? At the end of the meeting, when we come to a decision, am I afraid that you're going to call me back 2 days later and change your mind? No, your entire team was there. You heard everything. You got it. You got everybody on board, and we all agreed together. A team is so important. I can't stress enough that you bring your advisor and your accountant, and we talk together, so that there's an open line of communication. TLC estate planning strategy. So this is what we use in our office. Now, I'm going to ask a question. And after I ask the question, I'm not going to answer it. And then 20 minutes later, we're going to come back to the question. Okay, so this is going to take a little focus on your part, so bear with me. So my question is, if you die, what do you want to do with your assets? You want to give it to your spouse or loved one, right? Everybody agree with that statement? Okay? I think you're all wrong. Okay? I think you're all wrong. I don't even think you want to give it to your heir. And I'm going to prove it to you in about 20 minutes why I think you're wrong, and we'll see if you agree with me. Okay? Catastrophic illness protection. How many of us know who Terry Schiavo is? Okay? Why do we know who Terry Schiavo is? Can anyone tell me?
She was national from Florida on
Yep.
illness, and they cut her off.
Why we know about her is because we didn't know what she wanted. Okay? Her husband said she would not want heroic or life-saving measures. Her parents said yes, she would. And the only reason her husband didn't want it is because he wanted to remarry.
Yeah.
Do I know who's right or wrong? No, I have no idea. Do I care? No. What I care about is that for you, you put in writing what it is that you want so that that can never happen. Okay? If it's in writing and your living will directly says what you want, would we have even known who Terry Schiavo is? No. You know, it's a real shame that that happened. But we need to just make sure that it's in writing and we know what you want. Now, does anybody remember what I called a medical power of attorney without instruction? The God power.
Yeah.
Okay? Personal instructions are very important. Okay? My father, for example, I moved out of my house when I was about 18 years old to go to college. Okay? I haven't been at home for twice that years and more. Okay? Now, do I know what my father likes? I don't know. Do I know what he likes to eat? Do I know what books he likes to read? Do I know what his investment instructions are? Do I know what he likes to do? Do I know whether he wants heroic or life-saving measures? Do I know if he wants to attend family functions if he's disabled? Do I know? No, I have no idea. So my father did a personal care plan, and the personal care plan provides all of that. It tells me what he wants in this circumstance, what he wants in that circumstance, what's important to him, what's not important to him. He wants to go, for walks twice a day. He wants this, he wants that. Does that help me when I'm his power of attorney and he's disabled and he can't tell me what he wants? Heck yeah, it does. So that's no longer the God power or no longer the blank check because I now know exactly what it is that's important to him, right? Now the living will we certainly put in there. It's taken care of. We'll make sure you're taken care of in those situations, but there are so many other things that we can do. Remarriage protection. How many of us have heard about Fred and Wilma? Anybody? All right, well, let me tell you about Fred and Wilma. They were married for 45 years. They're sitting on their front porch and they're rocking in their rocking chairs. And Fred looks at Wilma and says, Wilma, if I die, are you going to date somebody else? And Wilma looks at Fred and says, Fred, what are you talking about? It's a beautiful day. It's a great breeze. Why are we even having this conversation? No, Wilma, it's okay. If I die, I'm okay if you date somebody else. Whatever, Fred. Okay, fine. Let's just rock. So they go back to rocking. A few minutes later, Wilma, yes, Fred. If I die, are you going to let him drive my truck? She looks at him and says, Fred, what are you doing? Why are we having this conversation? You're ruining a great day. He says, no, Wilma. It's okay. It's fine. If I die, it's okay if he drives my truck. A few minutes later, Wilma, yes, Fred. If I die, are you going to let him use my golf clubs? Absolutely not, exclaims Wilma. Fred looks at Wilma and says, wait a minute. I asked you if you were going to date, you hemmed and hawed. I asked you if you can let him drive my truck, you have no idea, and you got all upset with me. I asked him if he's going to use my golf clubs. Absolutely not, you exclaim. No, she says, he's left-handed. Right. Thank you for laughing. I appreciate that. It's a good participatory moment. Now, my question is, do you care?
Yeah.
Okay? Some people do, some people don't. Now, there is a very technical term. Sometimes it's called the anti-bimbo or anti-stud provision. There's a lot of very technical terms for it, but ultimately all that it means is, hey, you do whatever you want to do with your half. You can give it to whomever you want, but my half, I want to go to the kids. Now, how many of us in the room, and I don't want you necessarily to raise your hands, but just think, how many of you know somebody who lost a spouse? All of us, right? Of those people that know somebody who lost a spouse, how many know somebody who started to date somebody else? Okay, almost all of us. Of those people, how many of those examples the money went to the spouse or to the new friend, the new boyfriend or the new spouse and not to the kids? Right? A lot of times. Again, the question is, do you care? I would argue yes. And there are provisions, as I said, the anti-stud and the anti-bimbo provision that will prevent that. Okay? So your job is to decide, is that something that's important to you? Creditor protection. Financial advisor and client met and they ran all the numbers and they decided that they would get a $2 million life insurance policy for the spouse. And they came to me and they said, Jeff, we're going to have this $2 million life insurance policy pay out to wife upon death. And according to our actuarial tables and all those really fancy things that are far above me, we believe that spouse will be able to live off of about $90,000 a year for the rest of her life. So, do we all agree that $90,000 a year in a house that's free and clear is plenty of money in York, Pennsylvania?
Anywhere.
Yeah.
Anywhere. So we agreed that the husband took care of the wife. Wrong. Wrong. Here's the second part of the story. Spouse leaves the financial advisor with a check. Check in hand, right? Debtor-creditor law says, if you have access to the money, so do your creditors,
Creditors.
right?
Right.
So does she have access to it? Absolutely. She has the check. There's no better form of having it than having it, right? So she's driving down the road after having the check in her hand. Her kids are in the back seat and they're bickering. She turns around and says, if you kids don't knock it off, she turns back around into a school bus. Okay? Several kids are injured. Some die, unfortunately. But one thing is for sure. What does every child have these days attached to their hip? A cell phone. And they call 1-800-THE-HAMMER. Right? For my friends at Catherine Mary Briggs in Greenberg, to get results you deserve. Right? Absolutely. So they pick up the phone, they call somebody. So let me re-ask the question. Did the husband take care of the wife when he gave her $2 million? No.
No.
Because who now has that $2 million?
Kids.
The estates of the kids who died. Okay? Is there anybody in the room who is married? Anybody married? Okay. So Lou, this is $1 for video purposes. I'm going to leave it there, but that's your $1, Lou. Now upon your death, what do you want to have happen with that $1? Now that $1 represents everything that Lou owns. Whether it's $1 or $1 million, it doesn't matter. What do you want to do with that $1? You want to give it to your wife. Good answer. This is videotaped. That was good. I disagree. I think he loves his wife way too much to give her this dollar. Now, if Susan was in the room tonight, this is the point where she would be nudging Lou saying, this guy's crazy. Let's get out of here, right? He's a few marbles loose of a good game there. Now, I disagree. So let me ask you, what is it about this dollar that Susan would like?
What it can provide for her.
What it can provide for her. She can touch it, she can flip it, she can crunch it, she can do whatever she wants to do with it. So what Susan really likes about it is simply the fact that it's hers. She can control it. Do we agree?
Yeah.
Okay, now, let's flip the game a little bit now, Lou. This box is given, your wife now passes away. And she says to you, and I say to you, now Lou, if you had access to this box, you could put whatever you want in it, take whatever you want out of it, do whatever you want to do with it, and you're the only person who has the key to it. Are you okay with that? Yeah. Heck yeah, that's no different than this, right? Do we all agree?
Mm-hmm.
Now, it can't be that good, right? If it were that good, we'd all do it, right? Now, if I said to you, you can be the trustee, but we have to have another trustee. Right? I knew there was a catch. Darn it. Give me the name of one of your children. Emily. Okay. So Emily is now your co-trustee. So you pick up the phone one day and you say, Emily, dear, I'd like to buy a new car. And Emily says, Dad, what do you need a new car for? Your 76 Dodge Dart, that thing runs like a top. And the Rust, that provides the best air conditioning known to man. And you say, whoa, Emily, you're fired. Ooh, you have the ability to fire her. So you pick up the phone. Do you have another child?
I do.
I do. What's his name?
Matt.
Matt. All right, so you pick up the phone, you call Matt, and you say, Matt, you wouldn't believe this. I called Emily. I told her I wanted a new car. She told me that 76 Dodge Dart runs like a top and that the air conditioning was great because of the Rust. And Matt said, Dad, you need a new Cadillac. Matt, you're hired, right? Matt's going to cooperate with us. So we have the ability to fire and hire. Now, let me change the facts a little. Your wife passes away. You pick up the phone and call your daughter Emily and say, Emily, dear, I met somebody. And her and I are going to go across the country together. In fact, we're going to go across the world together. So I need you to write me a check for $20,000 for my trip. And Emily says, sorry, Dad, I can't do it. And you say, Emily, you're fired. And what does Emily say? Mom put in the anti-stutter, anti-bimbo provision, which says that when you start to date or live with or cohabitate or marry, whatever you decide it is, you can't fire me anymore. Ooh. So, is that a little soft hammer? Right? For the purposes of our example, though, we have the ability to hire and fire Emily. We have the ability to change the terms of the document. We have the ability to get in it when we want to do. We have the ability to close it when we want to close it. What do you think? Not bad, right? We have the access to hire and fire, change the document. Pretty good. We'll talk a little bit later about some of the details. Divorce protection. You and your wife are now gone. I'm sorry. Somebody has to die in the stories. Emily and Matt are very close. And they kept the trust that their mom and dad put together for them because they figured, hey, if it was good enough for mom and dad, it's good enough for us. So Emily calls Matt and says, hey, Matt. He says, yeah, sis. I'd like to buy a new house down in Florida. So I have a place to visit down in Florida. And Matt says, nah, Emily, I'm not giving you the money. And Emily says, Matt, you're fired, right? And he says, whoa, wait, hold on 1 second. Hold on 1 second. Let the trust buy the house. Let the trust pay the utilities. Let the trust pay the expenses. We'll title it in the name of the trust. You can use it whenever. You can visit it whenever. You can do whatever you want to do with it. And Emily says, okay, that sounds fair. Okay, sis, that's okay, bro. All of a sudden, fast forward. Emily is now married. She's down in Florida with her husband. Her husband's out on the golf course. And he comes back to the house one day and he says, Emily, you won't believe it. I met the most amazing woman ever. And she says, what? And he says, and I'm leaving you. And we're going to get a Harley and we're going to ride across the country. And when I come back, this will be real easy. All you have to do is leave the keys to the Florida house. You take the York house, write me a check for half of the assets. We don't have to fight with lawyers. We're good. So he goes on his trip. He comes back. Who cannot get into the house? Spouse. Because who didn't own the house? Emily. So if she didn't own the house, she doesn't owe him anything in the divorce. The house was owned by the trust. Woo! Was he surprised when he got home? Absolutely, he was surprised. Shocking, right? So, let me ask the question again. When you pass away, do you want to give somebody the dollar that they have access to, but so does everybody else? Or do you want to give them a box that has a beautiful bow on it, that they can get in, they can close it, they can get out, they can fire the co-trustee, they can hire a new co-trustee, and they can change the terms of the document? What do you think? Right? Creditors can't get into this. Pretty nice. Values promotion. Did you know you could promote your values through trusts? Absolutely. I had a client who came to me and said, Jeff, my son or daughter is going to get an education. I don't care whether it's a life education or an academic education. It doesn't matter to me. So in order for my son or daughter to fire the co-trustee or to have outright access to the money, they have to do one of two things. Either first, attain the age of 50, or if they get a bachelor's degree, 45, a master's, 40, a doctorate, 35. Does that give that child incentive to get a doctorate? Absolutely. But what if he doesn't? Is that okay too? Yeah, he gets the money at 50. Whatever he chooses to do, that's his business. And the dad set it up that way. And you can do anything you want. I've had clients who have put provisions in that say you have to live with the same person for at least 5 years. I've had clients say you have to get at least a 3.8 in college. I mean, you can put whatever provisions you want or any stipulations that you want in the document to promote your values. Tax, okay? Remember earlier I mentioned that I have a master's of taxation. So this is something that's near and dear to my heart. The one thing that you are allowed to do is to pass an unlimited amount of money to your spouse. Now, is that always the best thing to do? Not always, okay? And we'll talk later about why that might be. We'll give you an example. There is an annual exclusion that is $13,000 a year currently, and that does go up based upon inflation. That means that I can give $13,000 to everybody in this room, to all of your kids, to all of my neighbors, to all of my kids and all of my grandkids. If it's just $13,000 to each of you, do I owe taxes? No. Does the recipient owe any money in taxes? No. It's $13,000, annual exclusion. Government says you can do whatever you want to do with it. Have fun. The minute that I exceed $13,000 to any one person, I now have to let the government know that I exceeded $13,000 to any one person. So currently, for this year and next year, there's a federal exemption amount that can be used either during your life or at your death, or a combination of both, of $5 million. So that means that I can give away $5 million. How much do I owe in tax? Zero. How much does the recipient owe? Zero. I have to file a federal gift tax return to simply let the government know. Government, I gave away $5 million. I had $5 million to give away. That means I owe you zero. Okay. So that's the federal government. So the federal, now I can give 2.5 away during my lifetime and 2.5 away at death. Okay? That's only good for this year and next year. In 2013, on January 1st, the federal exemption amount goes back to $1 million. Is there a big difference between 1 million a person and 5 million a person. A very, very big difference. I personally don't feel that it's going to go back to a million. I think Congress is going to step in and do something with it. But we don't know. In 2006 to 2008, it was 2 million. Now it's 5 million. We don't know what will happen, okay? It's up in the air. We're assuming it's not going to go back to a million, but it's just something to keep an eye on. My advice is always remember this. There's reasons to make decisions. There's tax reasons, there's estate planning reasons, and there's Medicaid reasons or long-term care planning reasons. So if I make a decision based upon tax reasons, could that be a good tax decision? Sure. Could I be making a horrible decision over here? Yes. And let me give you an example. A lot of grandparents like to help grandkids pay for their college tuition, buy their books, fix the transmission that went out on the car, wedding gift. If I, as an individual, give that money away and it's less than $13,000, or I filed a gift tax return and used my exemption amount, do I owe taxes? No. Does the recipient owe taxes? No. So I did a good deed, right? Maybe. Now, fast forward 2 years, I become very ill and I go into a nursing home. Anyone know what the average cost of care is currently in a nursing home?
6,000 a month.
Higher.
$100 to $180 a day.
Higher.
More than 6,000.
It's about $8,000 a month. 7901 is currently the average in this area.
In
A
this
month.
area, in your-
Yes, a
No,
month.
that's fine.
Okay? That's for your bed and for your food. I have a husband and wife who are currently in a nursing home, $240,000 a year for the two of them. So this is a rhetorical question. I don't want anyone to answer this question, but you know your personal situation. If you and your spouse were going at a clip of $240,000 a year, how many years would you make it before you ran out of money? Not many, right?
1 month.
Yeah. not many. So here's my question. What are the different ways to pay for long-term care?
Insurance.
Shout it out. What type of insurance? Long-term care insurance. Good long-term care insurance policies have inflation riders on them.
Exactly.
Okay? Make sure you have that. Also, what is one really, really good thing about a long-term care policy? It provides for in-home care. Right? That's a great tool. That's a great benefit to get. You can get benefits in the home. You can stay at home. You don't have to go into a nursing home. You don't have to go to an assisted living. You can stay in your home and get the benefits. Yes.
Can I take you back just a moment, Jeff?
Go ahead.
If I may? This gifting situation,
Yeah.
13,000, or when it goes back,
Mhm.
reverts to a million, whatever, wherever it stands. Fast forwarding to now you're into Medicaid, Medicare.
Hmm?
And that eats up your resources
Yep.
rather quickly,
Yep.
obviously.
Yep.
And I'm staggering on this question, but I think you see where I'm going.
Hmm?
And let's say this gifting occurred within the last several years,
Yep.
5 years, 4 years, whatever. Does the Fed or Medicare have the right to come and assess this money that was given
Yeah.
in hindsight?
Yeah, let me explain that. I was getting there, so just if you could
Okay,
just hold
sorry.
on. No, that's fine. Just let me explain it in a more simple terms so we're not getting confused. So one way to pay for my care is long-term care insurance. One way to pay for it is
Cash.
cash. How long would we make it? The other thing that you can do to pay for your care is Medicaid. Okay? Medicare will pay for the first 100 days. There are deductibles and things, but Medicaid will pick up. Now, what Medicaid is a program that assists people who don't have assets. So Medicaid says, I will help you. We will pay for you. We don't have a problem paying for your care. But in order for us to do that, you need to produce for us 5 years of records, 5 years of bank accounts, 5 years of every statement of every account that you've ever owned, so that you can prove to us that over the course of the last 5 years, you haven't given away assets and not received value in return. So what I mean by that is, if you paint my house, Morris, and I give you $10,000 to paint my house. Is that okay?
Yeah.
Well, maybe. As long as the value to paint my house is worth $10,000. But let's say the value to paint my house was only $5,000. $5,000 is a gift. $5,000 was compensated. Now, that 5-year look back thingy, all that means is when I bring a box of all of my stuff to the Medicaid office or to the CAO, what's in that box is 5 years worth of records. So if I transferred the asset 5 years and 1 day ago, is that asset in there? No, because it occurred outside of the 5 years. They never even see that transfer. That transfer never occurred as far as they're concerned. So what happens is grandparents a lot of times provide all this money for their grandkids. Cars, weddings. They run out of money. They go into the nursing home. The nursing home says, how will you be paying for your stay? And you say, I don't have money. Medicaid's going to pay for it. You fill out the Medicaid application and you show that you transferred $40,000, $50,000, $60,000 to your grandson. Do we have a problem?
Yes.
Depending on the
Houston,
date.
we have a problem. Exactly. If those transfers occurred in the past 5 years, we have an issue. So before you go and start transferring money away because all these tax attorneys and all these accountants are saying, by the end of 2012, the federal exemption amount's going back to $1 million. You need to gift all your money away to get it out of your name. Well, maybe for tax reasons, but always realize that there's always something else that can kick you in the butt if you make a bad decision. Because theoretically or practically what happens is, I need care, but I can't pay for it. Well, I can't qualify for Medicaid. And let me ask, if you go back to the grandson that you gave money for the wedding or you gave money for the transmission, are they going to have it?
No.
No, they're not going to have it. They spent that long ago. So for tonight's purpose, I don't get into the very nitty-gritty of Medicaid, and I don't do it intentionally. The reason I don't do it is because what I have found is people like to take what you say and run with it. But every situation is different. There are exceptions, there are hardships, there's all kinds of things that are in the Medicaid laws. So for the purpose of tonight's workshop, my point to you is simply this. Before you go and make a decision to transfer assets or to gift, talk to a trained professional. One of the key things, I think you mentioned it earlier, Pat, was putting your son on the account, right? Now, let's look at it from a tax standpoint. From a tax standpoint, I have now added my son to this account. So as long as that transfer is more than a year and I die, if I made that transfer more than a year ago and I die, I saved 50% of the tax. Because all that's taxed upon my death is 50%. Who owned 50% of it? Me. Who owned the other 50% of it? My son or spouse, whoever else we have on the account. Okay, so what you're thinking is, oh, great. Well, then for Medicaid purposes, I'll just transfer half to the son and then I'll save 50% of it. Does that work? No. They look at who contributed the money to the account. So if I contributed the money to the account, Medicaid says that's 100% available. I mean, my best example ever to give to people is Medicaid says, wow, we love the federal government. The federal government is so nice to say that you can gift $13,000 a year and that you can give $5 million of an exemption. That's really nice of the federal government. Do they look at that the same way?
No.
No. If you transferred more than $500 in any 1 month, we're going to look at it. We're going to cause an ineligibility period. You see how these rules are not the same and they're very different? Make sure you see a professional before you make any decisions on those things. Pennsylvania. If you're living in the state of Pennsylvania at the moment of your death, we want our money. So Pennsylvania says, hey, that's really nice of the federal government to give you a $5 million exemption. We tax from the first dollar. So if you die in Pennsylvania and you transfer it to a spouse, it's a 0 rate. What did I not say? I did not say it was exempt. I said it was a 0 rate. Could that change? Theoretically. Years ago, it was like 6% to a spouse. Right? I don't think it will, because the one thing about Pennsylvania is they try to protect the marital unit, but it could. Lineal descendants, 4.5%. Siblings, meaning your brothers and sisters, siblings, 12%. And anybody else in the world, including your nieces and your nephews, 15%. Okay, so everybody, so you see the difference between Pennsylvania and federal. Now, in Pennsylvania, Pennsylvania says life insurance is not taxable in Pennsylvania. So let me give an example. I die and I give $1 million of a life insurance policy to my daughter. I pass away and I own nothing. I have creditors, I owe mortgage, I've got more people knocking down my door for money than you could possibly imagine. So my daughter says to all my creditors, I'm really sorry. My dad has nothing. He's broke, he died, he was way in over his head when he died. I'm sorry for your luck. Guess what the creditors get? Nothing. Zero, right? There's no money. How can they get anything if I don't have anything? But what does my daughter get to keep? The life insurance. Because life insurance is a non-probate asset. It doesn't go through probate. All that the creditors can get is what's through probate. So that life insurance policy that was a non-probate asset, she gets to keep. And the poor creditors get stiffed, if you will. Right? Not bad. Life insurance is a pretty good tool. Now, I ask this in every case. I want to make sure we're all on the same page. Am I licensed to sell any insurance products?
No.
No. Do I get any kickbacks or commissions from a licensed agent? No. Now, does that mean that there are no attorneys who are licensed who get kickbacks? You're clearly educated, Pat. There are a lot of attorneys who are licensed and who in the meeting will say to you, well, as part of our estate planning package or what we're recommending to you, we recommend that you do all these documents with us. And oh, by the way, you should also do this $2 million life insurance policy and this disability policy, and I get a commission off of it.
And they're required to do just what you finally said there.
Yeah.
To note that they have an interest.
Correct.
Fiduciary interest in.
They're
X, Y, and Z.
absolutely, they're required to put it in writing and to have you acknowledge it. Now, do I think that that's still okay? I don't. Because am I telling you that you need these products because they're really what's best for you? Or am I telling you need them because I'm making 50% commission on the back end? You guys make that decision. But I have already disclosed to you that I am not licensed and that I do not get any commissions or kickbacks from anybody who I refer to. My point in this workshop is simply to say, life insurance is a non-taxable event. It's not subject to creditors. It's a pretty good idea. Pennies on the dollar for what you're going to get in benefits. Long-term care insurance also pays for your care. So what happens is you get either a 3-year benefit, a 5-year benefit for long-term care, or you get a $200,000 benefit, a $100,000 benefit. I mean, there's all kinds of policies out there. But then that pays for your care. So that when you're in a nursing home, your care is being paid for. Or if you're at home, your care is being paid for. Two incredibly important and powerful tools in an estate planning package or an estate planning decision. You need to speak to your advisor about what's important. Certainly, if you want to talk to me about it, I'm happy to give you some suggestions and also the name of some really good advisors. So I want to give you an example of what happens when we just throw all of our assets into a non-probate or we don't think about how we have our estate configured. If you take a look here at this slide, and you'll notice I have 2006 to 2008. The reason I did that is because currently, this year in 2011, it's a $5 million exemption. 99.7% of the United States does not have a federal estate tax problem, right? So I don't want to use a $5 million number because all of you will tune out and you'll say, well, that doesn't apply to me. So I wanted to go back to what it was in 2006 because remember, in 2013, it's set to go back to 1 million. So I'm using these numbers, which is 2 million, just to hit home a point. If you look at my example here, husband dies with $2 million. His total estate is $2 million, but he gives everything over to his wife. Because remember, you can give an unlimited amount of money to your spouse. Do we remember that? So if he gives it to his spouse, he dies with 0. If he dies with 0, he could have had $2 million, The excess is 0, which means the tax due is 0. Good result, right? Yeah, no tax due. That's a good result. No, it's not. Now the wife dies. She has her 2 million plus his 2 million. She's allowed to have how much? 2 million, which means she has an excess of 2 million. Uh-oh. Now, back in 2006 to 2008, I'm going to say it was $1 million tax. That's not exactly right, but I'm in the ballpark. So by you not having a lawyer, not getting a will done properly, not allocating your assets properly, you just cost your estate $1 million of tax. So here is my offer to you tonight. I will do your estate planning for free, as long as you have a federal estate tax problem. And in return, all that you have to give me is what I saved you in taxes. What? That's not fair? Aw. I thought we were going to save lawyers. We didn't need lawyers. Now, I'm going to make one quick comment. This year is the first time ever in the history of the federal estate tax that they are allowing the spouse to elect to take on the federal exemption amount of the other spouse. So if I die, my wife can elect to take my 5 million. So when she dies, she can have 10 million. This is the first time they've ever allowed it. First time it's ever happened. So part of the reason why I didn't use the numbers from this year is because most of the time, if you have that kind of money, you're going to elect to take your spouse's election amount. So this example wouldn't apply. But it's the first time in the history it's ever happened. A lot of scholars that I've read have said that they're not going to continue to do that. They're going to eliminate that. Regardless of what the amount is, they're going to eliminate the election because they want you to have to use it when you die. So this example shows the importance of making sure that you have your estate plan set up properly. Now, for those of us who have a federal estate tax problem, it's okay. We can set up A/B trusts. Have we ever heard that? Marital family trusts, right? I'm just trying to throw the buzzwords out. So what we do is we transfer up to the exemption equivalent to the family trust, and we put the excess in the marital trust. That way, we use up the exemption that we're allotted, okay? But we still give the wife all the other money that we have, so she can still use it. We give all the money to her, that's the exemption amount, and then the kids get, the first 5 million in this case, and she gets everything else. So we're still using up our 5 million, we're not wasting it, right? Now let's talk about trusts. There are different trust types. There are irrevocable trust types that were the tax trusts. Remember we talked about the tax trusts earlier? No control, no income, no principal, can't be the trustee, can't be subordinate to the trustee. Who wants to run out and do those? No, right? Not a chance. That's what you think of when you think of trust. When you walked in the room tonight, am I right that that's what you thought of? Absolutely, everybody does. Now, if I don't have access to it, who else doesn't? My creditors. So nothing is subject to loss, but that doesn't give me enough to want to do it. Because remember our definition of estate planning. I want to control my property while I'm alive and well, and plan for me and my loved ones if I become disabled. How well can I control my property if I can't control it? I can't. So nobody wants to do that. Now let's talk about another type of trust. This is what I referred to earlier as an estate planning trust, also known as, in some forms, what is called an income-only trust. There are a bunch of them. I don't care what you call them. The point of these trusts are simple. The point of these trusts are that you still have some control. You have the ability to hire and fire the co-trustee. You have the ability to change the terms of the documents. Now, you have to give up something, right? I mean, if you didn't give up something, then clearly, if I had access to it, so would the creditor. So what we do in these types of trusts is we say, okay, I have access to it through a co-trustee. So remember how I said I have access to the money through Emily, through my co-trustee. I have the ability to fire Emily. And in these income-only trusts, what that means is I have access to the income. So the income is always spit right through to me. So I can live off of all of my income. I have no issues. Now, the one thing I've learned about York County is that people brag to me that they still have their money from communion, from confirmation, and from all of their graduations that they ever graduated from. Their advisor and they are the most intelligent people ever. They've never touched never touched their principal. They live off of their income. I am so smart, I am so good. And I say to them, wow, well then you really ought to think about this type of trust, because you'll always have access to your income. You'll give up right to your principal. And if you give up right to your principal, that means you don't have access to it. Who else doesn't have access to it? Your creditors. Great result. So what do they say to me? Whoa, Jeff, the minute I do that, I'm going to need access to my principal. I know I am. It's going to be, that moment will be the first time in the history of the universe that I needed access to my principal, but it's going to happen that day. Right? And I say, that's okay. That's fine, because here's what happens. Let's say Lou's basement floods. Lou has some money that he left out to live off of, some money that he has access to in his revocable trust or in his own name, but he doesn't want to use that. He wants to keep that money for other things, for trips and things. The income that he gets off of the trust isn't enough to live off of. So Lou picks up the phone and he says, Emily, dear, I need to fix my basement and it's $20,000. And she says, okay, Dad. And he said, I'm the trustee. I'm going to write you a check. The only thing that I did in the document was I said that I couldn't assign the principal to myself, but I never said that I couldn't assign the principal to you, my daughter. So I'm going to write you a check of the principal. You would then, in return, are going to be a wonderful daughter, and you are going to then give it back to me. And I'm going to go buy or pay for my basement. And Emily says, yeah, Dad, that's great. So you write the check to her. 2 days later, she doesn't show up. And you say, Emily, where's my money? Where are you? Dad, you wouldn't believe it. I was driving down the road, and I passed the car dealership. $19,999, the car I've always wanted. So it was a sign. So I bought the car. And you say to her, wow, I hope you love that car. I hope that car is the best thing you've ever done. Because guess what? You're fired. And not only are you fired, my dear, but I'm going to change the terms of the document. And guess who is not going to ever get another red cent from me again? You. So let me ask you, do you really think your child's going to do that? No way. Not a chance. They're not stupid. They realize that if they don't play the game, they're not going to get anything in return. Now, creditors, they try to argue all the time. Well, Your Honor, the court, we know what's going on. She's not ever dumb enough to not give the money back, because if she does, she's going to get fired and she's going to be written out of the document. And the courts say, but you show us where it says that. Does she have to give that money back? Absolutely not. Not a chance. Now, here's the best part. Remember I told you that there's an annual exclusion amount of $13,000 a year? Emily uses her exemption amount. She's married. Her spouse also. So that's 26 grand that we can get to Lou. Now, Lou's married. So Emily and her husband can actually get 26 plus 26, which is 52. $52,000 a year. Now, I promise you, if you need access to your principal, you're not going to need access to 52 grand a year, because you're going to leave a lot of money out, plus you're going to have access to all of your income, plus this. So you still have control. You have access to all of the income and none of the principal, except I would argue you do have access to the principal because you can get it. Go ahead.
Just a quick gift question.
Yeah.
You just a couple minutes ago said you could exceed that limit as long as you file a return.
Yeah. So even if we ran out of annual exclusions, I could still give up to $5 million and file a gift tax return, and Emily could still give them up to $5 million back in the next 2 years. So that's a great thing. So there's really no downside, particularly with the exemption amounts as high as they are right now. So my point is simply that you have control. You can have your cake and you can eat it too. The secrets. Remember, an RLT is a revocable trust. That means I can put whatever I want in it. I can take whatever I want out of it. It avoids probate. But if I can take whatever I want out of it or put whatever I want in it, who else can? The creditors, right? The typical irrevocable trust is a closed box. I can't change it. I can't control it. I can't change it. I can't do anything with it. That's a federal estate tax tool. That's not what we're talking about. If you look at the income-only trust, or the trust that I talked about there in the middle, which is the trust that we use in our office, does anyone want to tell me why there's a little thing there hanging up? Does everyone see that? That's a trap door. So when I want the door to be closed, what do? Boop! Emily, can I have access to the money? No, Dad. Okay. If she says no, can my creditors get at it? No. So in some cases we fire her. In some cases we hug her. Right? So it's a trap door. When I want it opened, it's opened. When I want it closed, it's closed. Does that make sense? Okay. Now, for the business owners in the room, and I know there are some, there are ways that you can take your business and put the business in this trust as well. This isn't just a Medicaid trust. This isn't just a long-term care planning tool. You take your business and you put it in the trust, and that way, if you screw up in the business, you have an LLC or a corporation, you can't get out, okay? If I injure somebody in my business, they can go after my business, but they can't go after my personal assets, correct? But if I screw up in my personal life and they get a judgment against me, can they go after my business? Yes. Absolutely. But if I put that business in the trust, can they now go after my personal assets? No. So it's also a business planning tool. So for those people who are business owners and you want to learn more about these also work in those purposes as well. It's a very, very diverse trust. A lot of things you can do with it. Now, what I want to do quickly is I want to take a look here. Did we talk about how to protect our assets? Absolutely. Yeah. That's the trust we talked about, right? Protecting our assets, powers of attorney, guardianships, will, medical power, living will, titling of assets. I think we talked about the advantages and disadvantages. Putting our son on our account. We definitely talked about that several times. And gifting of assets. Absolutely. So let me ask, why do we do it? We do it because of the family, right? When you walked in today, remember our estate planning pyramid from earlier? The bottom was the foundation, and that's our family. When you all walked in, you came in saying that what was most important? The money, your stuff. So what we did was we turned your perspective upside down. We now put the focus on our family, not our stuff. Okay, so we've turned it upside down for you. What can be done? Like I said, those are the rules. That's the easy part. The tax code, the Medicaid rules, that's up here. That's what you hire a professional for. The secrets, well, that's the stuff that we do. The trust that we talked about, the ways that we can do things, those are the things what we do is we take what's important to you and your personal family goals, and we tie it all into what we know how to do to protect you and your family. So my question is, 2 hours has come and gone. Did we have fun?
Yes.
Did we learn a lot?
Mhm.
Did the time go quickly?
Yes.
So,
Your success.
thank you. So in return, what are you going to do for me?
Call
You're going to
Jeff.
fill out. Hey, you know what, Morris? I like that better. You call Jeff. Yeah. You're going to fill out the evaluation for me. I appreciate it.
Already filled out.
Yeah. Now, what I would say to you is when you take a look at your evaluations, you'll notice that there's a box down there that says, contact me in X number of days to schedule the vision meeting. Remember, the vision meeting is absolutely free. If at the end of the vision meeting you decide you don't want anything, what do you owe me?
Nothing.
Smile and a handshake.
Smile and a handshake. No monetary, nothing. It's a completely free meeting. There's no strings attached, no hidden agendas, no anything. So what I also ask of you is this. If you're thinking that you want me to contact you in 14 days, my request to you is that you just let me call you tomorrow, because if you check 14, I'm going to have somebody call you anyway, because guess how far out we're scheduling? 14 days. So that happens all the time. People want to check 14 or 21 days thinking, well, I'll just buy some time here and I'll forget about it for a while. Let us call you. Let us schedule the appointment, even if it's a couple weeks out. That way we'll get you on the schedule as quickly as possible for the free vision meeting. You'll notice at the bottom of the sheet that I ask for any names of anybody who might like this workshop. There is a workshop flyer of all the upcoming dates. We have our dates of workshops out 6 months. Please feel free to give me the name of somebody you think who might enjoy this workshop. We'll send them a flyer. If they tell us to buzz off, we will never contact them again. I promise they won't be put on any lists or anything. You'll notice at the bottom there's a box there for an e-newsletter. I offer an e-newsletter every 15 days. We talk about some really good areas of the law, some really good tidbits. Feel free to put your email down. There's no solicitation. It's simply an e-newsletter. You can choose to unsubscribe at any time. All right, does anybody have any questions? Well, I will stick around for a few minutes tonight. I really thank you for your time, and please put the evaluations up here on the front, face down. Thank you all very much. I really appreciate you coming. Have a good day.
Thank you.
Thank you.